Welcome to the SA Mining Desk, your essential partner in understanding South Africa's mining sector. We're a platform dedicated to simplifying the intricate world of mining, from government regulations and groundbreaking judgments to essential industry reports. We deliver clear, concise information to equip you for every step of your mining journey. Join your host, he unpacks the mining sector for us.
Hi everyone, and welcome to the SA Mining Desk, your partner in navigating South Africa's mining sector. In our previous episode on the case files, we looked into Mpilo and Zen Holding and Centurion Mining Company as they battled over a gold-bearing tailing dump worth an estimated 435 million rands, which was won by Mpilo and Zen Holdings. Today on the case file, we're unpacking an important judgment. Sefateng Chrome Mine, Pty Ltd, versus Minister of Mineral Resources and Energy and others. This case highlights what can happen when a mining right is granted without proper consultation and, even more importantly, when the minerals being applied for don't actually exist on the land in question. Let's dive in. Sefateng Chrome Mine has held a ceded prospecting right since 24 May 2013, giving it the exclusive right to apply for a mining right for chrome ore on the farm Waterkop 113 KT in Limpopo Province. They applied for a mining right on 24 May 2013, and by 12 September 2014, that right was granted, allowing them to mine chrome on the same farm. On the very same day in May 2013, the Minister of Mineral Resources and Energy, now known as the Department of Mineral and Petroleum Resources, DMPR, placed a 10-year restriction on granting new rights or permits on certain properties, including Waterkop 113 KT. This restriction, however, did not affect existing rights or renewals, meaning those who already had exclusive rights could still apply for or renew their own.
On 26 August 2013, Lethabo applied for a mining right covering several farms, including Waterkop 113 KT. Their application was accepted by the DMPR on 29 January 2014. Lethabo then informed Corridor Mining Resources, the previous prospecting right holder on the farm, about its application. Corridor, in turn, notified Sefateng, who immediately objected to the granting of Lethabo's mining right. Despite Sefateng already operating a chrome mine, the DMRE's Director General granted Lethabo mining rights on 26 June 2017, but for Andalusite and Magnesite, not chrome on the farm Waterkop 113 KT. Sefateng was aggrieved by the decision. They lodged an internal or administrative appeal, arguing that Lethabo's mining right overlaps with their existing operation. Lethabo failed to consult them as the lawful occupier, interested party, and existing miner, as required by the MPRDA. And finally, that the right was granted during the moratorium period, making it unlawful. On 12 January 2022, the minister dismissed Sefateng's appeal, saying Lethabo was exercising its exclusive right as a prospecting right holder. Lethabo applied for different minerals, Andalusite and Magnesite, not chrome on the farm Waterkop 113 KT. Sefateng was aggrieved by the decision. They initiated review proceedings at the High Court, Gauteng Division, Pretoria, on 11 July 2022. The DMPR chose not to oppose the application.
The case was heard by Acting Judge S. von Aswegen, who handed down judgment on 9 June 2025. Before dealing with the main issues, Lethabo raised 2 points in limine. Point in limine is a request to have a specific legal point decided before the main case proceeds. First, they questioned whether Mr. Gerard Jacobus Blau had the authority to represent Sefateng and sign the founding affidavit. The court found this argument had no merit. The board had properly authorized the case and the resolution was valid. Second, Lethabo argued that the review was out of time, claiming Sefateng knew about their mining right earlier. The court found that in terms of the Promotion of Administrative Justice Act, PAJE, the applicant has 180 days after the date on which any proceedings in terms of internal remedies, i.e. internal appeals, have been concluded. The court further found that both PAJE, save for in exceptional circumstances, and the MPRDA compels applicant in a review proceedings to first exhaust internal remedies. The court held that the 180-day period must be calculated from the date the administrative appeal was concluded, being 12 January 2022. Therefore, Sefateng did institute the review application on 11 July 2022 within 180 days. Both points in limine were dismissed. Now to the main grounds of review and how the court ruled on each one. 1. The moratorium. Sefateng argued that the moratorium, which was valid from 24 May 2013 to 23 May 2023, prohibited the granting of Lethabo new mining right. Lethabo's prospecting right, granted on 19 December 2007 for 5 years, expired in December 2012. So by the time their mining right was granted on 26 June 2017, they no longer had exclusive rights to apply. Exclusive right to apply is a right held by prospecting right holders that gives them the exclusive right to apply and be granted a mining right in respect of the land and mineral under their prospecting right. The court agreed the grant conflicted with the moratorium and was therefore unlawful. On this ground alone, the decision to grant Lethabo's mining right and the minister's refusal to overturn it should be set aside. 2. The unlawful acceptance of the application. Under the MPRDA, an application can only be accepted if no other right for the same mineral on the same land exists on the area applied for. At the time Lethabo applied for a mining right on 26 August 2013, which was accepted on 29 January 2014, Sefateng held a ceded prospecting right since May 2013, and its mining right was accepted and already in process and granted on 12 September 2014. The acceptance of Lethabo's application was unlawful and contravened the MPRDA. The court ruled that both the granting of Lethabo's right and the dismissal of Sefateng's appeal were unreasonable and invalid under PAJE.
3. Failure to consult. The court was clear. Consultation is not optional. It is mandatory. It must be done up front, before the right is granted. Sefateng, as an existing mining right holder, was a lawful occupier and interested party. Lethabo should have consulted them as required in the MPRDA. The purpose of this rule is to avoid overlaps, safety risks, and operational conflicts that arise when two companies try to mine the same piece of land. Lethabo's failure to consult Sefateng was a fatal flaw, and the DMRE's view that consultation could happen after the right was granted was an attempt to fix a clearly flawed right and was rejected by the court. 4. Minerals not found on the land. It was undisputed that the minerals granted to Lethabo, Andalusite and Magnesite, don't exist on farm Waterkop 113. Lethabo's Mined Work Program, MWP, listed several minerals, including magnetite, Andalusite, and chrome, but the right was issued for magnesite, not magnetite. The MWP has a fatal defect, a discrepancy between the minerals on the land, those listed in the MWP, and those granted in the mining right.
This mismatch meant Lethabo mining right is flawed, as it cannot be issued for minerals that are not included in the MWP or for minerals that are absent from the land.
5. Defective application and MWP. Lethabo's application also had major procedural issues: insufficient public participation, an incomplete mine work program which also contained numerous deficiencies, and a lack of reference to neighboring operations like Sefateng, Chromex, or Baoba. Due to these significant flaws, the Lethabo mining right should be reviewed and set aside. The court reviewed and set aside both the minister's decision on appeal and the Director General's original decision to grant Lethabo the mining right.
The court went even further It substituted the decision to grant Lethabo mining right and formally refusing Lethabo's mining right application. And that wraps up today's case file. Thank you for watching SA Mining Desk. On our next episode on the case file feature of SA Mining Desk, we will be looking into the case of the Anderson v. Silver Unicorn judgment, dealing with why the court refused to stop unlawful mining. It is going to be very interesting. See you in our next episode.